Attorneys, why you sometimes say no to cases. Story 1. In my experience, just get them to talk however you can, lots of open-ended questions. Get there early and establish a rapport with the plaintiff, joke off record about the coffee, building, table, local sports team, whatever. This is the type of depot that I'd 100% do in person. And from my experience in plaintiff side work, yes, firms will absolutely not take a case if plaintiff themselves is a liability. I've had plaintiffs during case intake tell me that they've suffered more than Jesus, or their back/neck pain from a minor fender bender can only be measured in the billions. We did not take those clients. Story 2. Defense attorney here. I feel frustrated at times because the jerk clients are tough to deal with and tend to be unreasonable and unwilling to follow your advice about negotiating a deal when the evidence does not support their position. I also regularly feel compassion because oftentimes there are inequitable socioeconomic factors that lead to criminal behavior. Mostly I feel I can rest easy knowing I'm part of a system of checks and balances, and when the system is working properly, the evidence will speak for itself, and that is how justice works. I am more likely to feel angry at the government than my client when the system doesn't work. There are a few cases here and there where you feel icky and have to create some professional boundaries. If you can't, then you may be ethically required to withdraw. But that is so incredibly prejudicial to your client, so we have to balance this with the professional rules of conduct to protect our client's rights. That's why it's rare for an attorney to request off a case on the basis of moral reprehensibility. I'd be surprised if Alex's attorneys don't dread going to visit the guy to discuss the case. Edit for clarification. Story 3. I don't have enough time. I've had the run of it all, man or woman or donut. My first trial was a one-armed motorcycle driver who got hit in the rear. He had 2 surgeries to the right ankle and some scarring. I asked him to show the jury his scars and the ankle that hurt him so much. So he slipped off his boot, pulled up his foot and dropped it on the witness table in front of him with a loud thunk. Despite my first time in trial as first chair, I knew that likely this tanked the case. I was able to settle the case with the insurance adjuster 2 minutes after the jury got the case, and 15 seconds before the jury came back with a verdict. Defense attorney knew he won through his binder and kicked it down the hall. It's actually one of my favorite stories because I shook insurance adjuster's hand, and as I'm walking back to my client to let him know that we're settled, the defendant comes running out of the courtroom, saying that the jury has verdict, which is when said binder got kicked. My dumb client still had the audacity to complain to me that we didn't get enough. Another interesting client was a power weightlifter. She was so distraught about not being able to use the gym the same way anymore. Lo and behold, defense attorney break out a video of her doing push-ups with her boyfriend on the back of her. Another intelligent client of mine at a deposition stated that she is depressed that she is unable to wear heels. This is a fine and normal statement and feeling to have. However, the defense attorney took the time to look under the table that we were sitting at and noted the client was wearing heels. Last gem, I can only disclose a little bit. Too long, didn't read. I had a lot of money into a medical malpractice case. My client was less than truthful as to the extent of the permanent injuries. Family and friends all backed up the client. Still don't know and won't know which of those friends and family knew or were duped. Don't believe any of your clients. Trust, but verify. Story 4. My dad, a public defender in a small, awful rural town, occasionally had to refer clients to other attorneys because of caseload or conflicts. He practiced 25 years and often defended generations of families. When he was fairly new in his position, he defended a man accused of abusing his young nephew. Due to a technicality, the charges were dismissed. Years later, the now-grown nephew was accused of abusing a child, and my dad was assigned his case. Horrified, my dad told his new client that he would absolutely find replacement counsel for him, as he understood that it must be terribly uncomfortable for the client to have to work with him. The client said, "No, I want you. You got my uncle off when he assaulted me, so I know you'll get me off for assaulting this kid." Dad didn't take the case. Story 5. I usually explain why the client has a poor case. The only times where I don't explain are when the client has obvious mental health issues. In those cases, I'll typically say that their case is extremely complicated and that my office does not have the resources to handle it. The last time this happened was when a husband came in to divorce his wife because supposedly she had injected him with nanobots. The nanobots had gone into his brain and were telling him crazy things, and supposedly the wife did this in conspiracy with his church to take all of his money. He wanted me to join the church as a party to the case and subpoena all of their records, like all of them, so that he could show how the church was controlling people's minds. Unfortunately, my office did not have the expertise and resources to handle a case of that size and complexity. Story 6. Yes, I will take cases of almost all kinds where I'm fairly certain we're going to lose, and maybe even lose badly. There's still a lot of value to be had in being there to make sure procedures and rules are followed, rights are respected, and the plaintiff/petitioner/state is forced to meet their burden of proof. Cases where everyone knows X is guilty/a dangerous parent/la fraud are often the cases where it is most tempting for people to take shortcuts and violate procedural rights, because what's the point, and so are often even more important to receive a zealous, but ethical and reasonable defense, which almost always just comes down to arguing mitigation and damage control. But I will be pickier with those cases. I will frankly inform the potential client of my opinion that their case is a stinker, why I think they are almost certainly going to lose, and what the expected outcome is. The biggest deciding factor in whether I will take the case or not isn't the money, it's how gracefully or reasonably they accept that opinion, and how realistic they are about what's possible. Sometimes, based on their response, I will quote them a dramatically higher price than usual, the jerk tax, or even refuse the case entirely. The biggest difference between being new and having 7 to 9 years of experience is knowing that no amount of money is worth having an unrealistic, unreasonable, and stubborn client who doesn't respect your expertise. Story 7. Money. In civil, everything revolves around money, and trial isn't cheap. I've been very successful at my firm because I manage client expectations from the start, and the biggest part is managing financial expectations. And to be honest, we don't know for sure that a client will lose a case. Similarly, we don't know for sure whether they will win. Juries and even judges are a gosh darn toss-up, and sometimes it's a coin flip. This is why 95% of cases settle. So instead of convincing my client they will win or lose, I just give them my opinion on their chances, how it's played out before, and then tell them that regardless of the outcome, it's going to be freaking expensive, and my estimated costs for each step. If their chances of winning are abysmal, I'll say something along the lines of, "I haven't seen your argument work, but I will give it a shot. But are you ready to pay me $100,000 to take that shot? Because if you are, I'll take it all day. I'm just letting you know that I don't think it's going to work, and that you're going to pay me a trial retainer of $50,000 up front for a chance at winning." I then send a detailed CYA, cover your behind, letter to client explaining our conversation. When you integrate realistic cost expectations, you quickly find most clients will suddenly be super reasonable. That or they'll find an attorney who will lie to them. Either way, it's the best, most ethical outcome for me. Story 8. One client that I turned away because I knew he was going to be trouble. It was a civil matter to do with his mother's will. The guy had burned through 3 or 4 lawyers before he came to see me, and it was obvious he was looking around for a lawyer who was going to tell him what he wanted to hear, despite it having no basis in law. During the initial interview, he was saying how he was suing his previous lawyer for negligence, complaining because he didn't get what he wanted. As politely as possible, I told him to leave my office and go somewhere else. Story 9. My first 8 years, I represented children, parents, and guardians involved in child protection matters. I lost constantly. The judges are highly likely to side with the state and order oversight, and often the best we do is mitigate the situation, limiting the time involved, or keeping the services targeted. Once a judge I met remembered my name from a one-day trial 2 years earlier. When I asked her why she remembered me, she said only 2 attorneys had ever won that type of trial in front of her before, and I was one of them. Now I work for the state, and I can count on one hand my losses. But my value isn't in the win/loss percentage, but the advice I give my client to either drop a case or pursue it. Story 10. There's already some good replies here, and I use those approaches as well, pointing out what the evidence indicates, saying they're likely to lose and have to pay $X plus costs. I usually start mild, like, the odds of winning are very low. I highly recommend settling. At the first pushback, I usually say something like, if you go to trial, or arbitration or whatever, you're just going to spend more money to end up in the same place. If they don't accept that, I usually combine bluntness with something weird or unexpected, so it registers better in their mind. I specifically remember saying the only way you win is if the other side or the judge seriously messes up, and you're better off giving up on this case and buying a lottery ticket instead. More than a few times I've had clients argue that they should succeed because of some vague notion of fairness, not rooted in any legal doctrine that uses fairness, or because losing means some business choice they made is no longer profitable or efficient, and I just say no judge is going to give a crap. I remember saying that to a client who had arranged a work schedule to minimize overtime costs, but it was clearly contrary to the hours of work provision in the collective bargaining agreement. At that point, it finally sank in that they really had no choice. It didn't matter how efficient it was, because it was just a flat-out breach of the contract. Story 11. It depends. Are they asking me to resolve the issue to the best of my ability or win at trial? I'll happily take a case with the understanding that the client is going to settle it and I can negotiate the best possible deal for them. However, I am not some divine being who can simply alter reality and make bad facts into good ones. I am not going to take some unreasonable or borderline frivolous position because a potential client wants to make a futile attempt to win. They can find someone else who will gladly take their money. As to what I would say, I would explain my opinion of the matter, provide a few avenues to resolve the issue, and if the client agrees with my strategy, then I take the case. If they disagree or if they are giving off difficult or unhinged client vibes, then I usually end the consultation and tell them I will get back with them. I'll then email them the next day saying I cannot take the case and may make some recommendations for other attorneys if the potential client isn't insane. Story 12. I did civil defense for business clients, and I would take cases where the client clearly was at fault all the time. My role would be damage control. Sometimes plaintiffs greatly overstate how much they are due in a breach of a business contract, for example, and if I can force the claimant down from a bogus number, I bring value to my client. Let's say you're sued for $100,000, and I cost you $10,000, but got them to settle for $30,000. I potentially just saved you up to $60,000. Story 13. My usual thought is that when you give reasons, their response will be to argue with you about your reasons, usually trying to tell you, the attorney, who they are coming to for legal assistance and advice, that their case has more merit that you, the attorney, see in it. I don't categorically not give reasons. Corny as it sounds, I think a big part of the process is making sure that everybody, at every level and step of the process, is heard. Sometimes that just means me taking an extra 20 minutes, if I have it, to listen to a person, talk to them, and hear the situation that they are passionate enough to consider coming to me for help with. For some people, that's enough, the sense that someone in a tie has listened to them and talked to them and agreed that something is unfair and meant it. If you're billing, there's a balance with your time, which is always like water in the desert. But I think leaving people who come in with a case you can't take, with the sense that they were listened to, that they were heard, leaves the door open with that person, who might later have an issue you can help with. If I think they want to get combative with my non-engagement, sometimes I will just send the generic letter. Or sometimes I will have the conversation with a built-in limit on how long I can have it, my next appointment, etc., to essentially confirm for myself that it was a client I probably wouldn't have wanted if they get belligerent, and that I dodged a bullet by passing. That also helps me not carry any lingering regret for passing. Story 14. I tell them the elements I require to take on a case, and tell them where their case is lacking, and encourage them to get a second opinion, and to keep in mind that a lot of attorneys will tell them nonsense about the reason they won't take their case when it's probably really what I already told them. I have never received a bad review for giving a potential client a no-nonsense rejection. Of course, if they sound like an unstable person, I will give a nonsense reason. Story 15. For a decent case but with low damages. I became a lawyer because I want to help people. Unfortunately, this is also a business. After a lot of thought and consideration, we came to the decision that we can't help you, because once you succeed, all of your recovery would be swallowed up by our fees and costs, and in good conscience, I can't make you worse off than you currently are. I encourage you to reach out to other attorneys, as they may see a way to both help you and not make you worse off for winning. Story 16. Loving your question how it throws in some shade that no lawyer would actually do anything charitable, needs to have some kind secret benefit, like a car. Many lawyers, like plaintiffs' lawyers, do cases for even less than free over their career. Less than free, we handle cases including financing the costs, make no legal fee, and also don't get repaid our investment. And if you're aggressive enough, this can occur annually. Then you add all of free legal consults that you never get paid for, and don't truly in work. So why then would we turn down a small fee case instead of pro bono work? The pro bono is likely very compelling, and/or includes legal issues that need to be resolved, or includes a group of people that really need a lawyer because the system is mistreating them, systematically, etc., etc. So if you consider all of these cases already making up your caseload, taking on a low fee is really the worst use of your time. I'd rather take zero fee from the beginning and go make a wave, instead of making $3,000 to fight over $10,000 to ayuk. We only have so much time to practice law, earn a living, take care of employees, and take care of financial liabilities. So in that last column of cases, it needs to be super profitable cases, as everything else is basically a loss. Why? Time. We don't have enough time to please everyone. Story 17. I am an admitted attorney, but I don't work primarily as an attorney right now. I'm in compliance. When I do pro bono work through my state's legal aid program, their malpractice insurance covers me. I also do pro bono work through a local immigration nonprofit, and their malpractice insurance covers me. I'm not insured if I do a very righteous paying case for a client without much recovery, and a small recovery would never be enough to pay the necessary insurance. For a lot of small firm and solo practice attorneys, it's flatly an insurance issue. They have to take cases that will recover enough money often enough to pay their malpractice insurance and other costs, while doing pro bono work is generally covered by the pro bono organization's insurance. Or, if you're at a bigger firm, rolled into the firm's insurance. The immigration nonprofit work I do is very routine and boring. The feds require a lawyer examine certain documents and agree they are actually birth certificates or marriage certificates or whatever. There's not a lot to it, and it frees up the nonprofit's paid attorneys to actually go to court. It's easy, and it's helpful, and it's frankly dumb an attorney has to verify the documents, but I'm happy to do that to help low-income immigrants get their green cards or citizenship status. I can go spend 6 hours in a conference room on a Saturday and work my way through 24 files, and that's legitimately helpful to people who need help, even though it's dumb that an attorney has to do it. I could go and do it when I had a baby, bring some toys and a coloring book with her and let her crawl around the conference room and get doted on by the secretaries while I verified documents. The cases I catch from legal aid tend to be interesting and kind of fun. Some of them are going after terrible landlords or things like that, which always feels good, although legal aid's paid attorneys can do those. Story 18. In my jurisdiction, we have a professional obligation not to advance entirely unmeritorious cases, but that doesn't mean cases which might or are likely to lose, only ones that will definitely lose. In the end, someone is always likely to have the worst case in a dispute, and someone has to represent them. Most disputes settle before trial anyway, so a good outcome for a client who has a weaker case might be a settlement on the best terms possible. They still need advice on that, and someone to represent them. While everyone would prefer to be on the winning side, you also don't always know the prospects of a client's claim until they've instructed you and you've considered the case in detail, at which point you can't easily step away from representing them. They might need to be advised that their case is weak, but they might be committed to litigation if proceedings have been issued. All in all, a case being weak isn't enough for me to turn it down, unless it's completely hopeless. Story 19. It depends on the type of law and the situation. Criminal defense lawyers will frequently take cases they know they will lose. Prosecutors in most jurisdictions are going to have an obligation to not advance cases without a good faith basis. When I was a prosecutor, we needed more than that. There was no punishment or issue with losing or dismissing a case, but advancing something that. Story 20. Sometimes unreasonable cases are brought by unreasonable or not very bright attorneys who think the case might have merit. Some lawyers don't know how to say no to a client and will file a frivolous claim if the client insists. This is called handing your law license over to your client, and it's bad practice. Sometimes they feel the case is weak but not frivolous, warn their client, and then go forward with the case, figuring it's their client's money to spend. This is arguably acceptable practice as long as the client fully understands that it's a long shot and it's genuinely not frivolous. I personally do not take cases like, unless my client is in a dire situation, and it's a rainfall this because I think it is unreasonable to spend money on long shot cases. Unreasonable people do not become reasonable once a case ends exactly as you predicted, and they certainly don't become more reasonable when it's time to pay their lawyer for a case they lost. Some lawyers don't care about credibility with the court so much, primarily those who do hardly any litigation and are unlikely to see the same judge twice. Those are the same lawyers most likely to not realize, until it's too late anyway, how weak their client's case is. Story 21. One of the hardest firings I ever had to do was an ethical/lying issue. I had a client who I was negotiating a plea deal for. The plea deal we worked out centered around how well my client was doing mental health-wise. I had made multiple representations to the court/prosecutor about the steps my client was taking to address his mental health concerns up to this point, and the pending plea deal was based on that. 2 days before we submit our joint submission, the client out of nowhere calls me up and I can immediately tell they are in the midst of some sort of psychosis incident. I had never seen the client like this. They were accusing me of all sorts of things, talking about how they lied about all the steps they were taking. I don't think they were lying initially, but who knows. And talking about how I was out to get them like everyone else. This put me in a real bind. 2 days from that call, I was supposed to walk into court and do a joint submission where I was going to go on and on about how stable my client was in the community and the incredible steps they had taken with their mental health, but how could I do that anymore based on that call? At the same time, if I walked in and didn't say anything about that, everyone would know something was up, and the prosecutor could pull the deal to my client's detriment. My only option, as I saw it, was to fire the client, encourage them to get some mental health support, and hope his next lawyer could pick up where I left off. Story 22. I've turned $2,000 in expenses into $50,000 case. It might not be a small case. Not saying yours is worth $50,000, but we don't have crystal balls. You may need plastic surgery scar revision. You may develop post-traumatic stress disorder. You may develop an infection. I certainly hope not, but sometimes what seems small at first can turn into a bigger case. But sometimes we take these cases and discover there is no insurance, and the other guy has no assets. Sometimes The case is a dud. Again, I hope this isn't the case. But this is the beauty of contingent fee cases. We take the risk, because most ordinary folks don't have $3,000 minus $5,000 to retain us, to investigate a recovery, and you might not want to risk that over $2,000 in bills. It also incentivizes the attorney to build the case properly. We don't always know if it will be a big case or a small case, but quote, if you're not fishing, you're not catching. Story 23. I think you gave a great answer. As a public defender, I'd just like to add that one of the reasons I think we get a bad rap is that we don't get to pick our clients. A private attorney can turn down bad cases or cases their office is not well equipped to handle. They can also fire bad clients. When these clients get passed up, they end up with me. I don't get to fire the jerk who expects unreasonable things from me. I had a client entirely unwilling to pay $250 in restitution to get the felony dismissed on the principle that jerk isn't going to get any more of my money, so I'll waste his and go to trial. I don't get to tell her that it'll be $25,000 for me to take the case. I just have to deal with her. Also, I think we tend to be more honest with clients. I don't need someone to cut me a check or get grandma to mortgage her house so I don't have to blow smoke up their asses. If their case looks bad, I can tell them early on. I'd love to make them feel better about the system, but, like you said, I just don't have that kind of time to spend on them. Story 24. I'm a public defender. I don't have a whole lot of room to bail on cases I'm assigned, no matter how horrible. I did punch out of one case, though. My client was a sovereign citizen who believed that because he no longer recognized the authority of the state to govern roads or motor vehicles, he didn't need a driver's license. He was very wrong. He insisted that I file his pleadings comprised entirely of pseudo-legal jargon and citations to obscure provisions of hilariously outdated laws and court opinions. I told the judge what he wanted to do and why I couldn't do that, because I took an oath to uphold the laws of the state, not argue that anybody can pick and choose which ones to follow, and that the client needed to represent themselves. Story 25. Someone I know was offered many thousands of dollars to represent a substance dealer who has been recently captured. He refused, and a colleague took on the offer, calling my acquaintance stupid for rejecting that kind of money. Well, the trial hadn't even begun when the lawyer who took on the offer had to leave the country with the youngest of her kids. Her husband, the other two of their kids, and her parents were supposed to meet her a few days later. They were all killed by a rival criminal organization. You do not mess with those criminal organizations. Story 26. When I was taking criminal defense cases, I had a gentleman come in and ask me to help him lie his way out of a driving under the influence. He had this brilliant plan where all his friends were willing to lie along with him and claim he was out of state at the time, so it couldn't have been him who was pulled over, field sobriety tested, breath tested, arrested, and jailed. This despite the fact that it was clearly him, with, I assume, his wallet and ID in his car, and he told me straight away that it was him. His belief was that, since it would be just the cop's word versus him and his friends, there was no way they could convict him. He seemed flabbergasted when I told him that no attorney was likely to assist him in perjuring himself. And I certainly wouldn't. Lawyers lie for a living, he said, and besides, the cops lied all the time. Why couldn't he? 30 minutes of my life I'll never get back. Story 27. These guys always end up pro se in my jurisdiction, too. I'm also public defender. I avoid picking up animal cruelty cases when I can. I'm not bothered by defending crimes against people and children, but animal stuff. No thank you. It's actually super common. I mean, look, defending any crime is part of my job. I'm not bothered by much, and in fact, the tougher the case, the better. I'm up for the challenge and great at my job. Nothing is worse than an innocent client. You all seem to be responding to this comment very seriously, and it's meant as a big generalization. People in my field have dark sense of humor and irreverence. We have to. So there's no way I can totally get out of this convo without many Reddit types being incensed or offended. That being said, I can try to explain it. People are complex. They have complex motivations, mental illnesses, and emotions. People, including children, also lie, cheat, make things up, because they're protecting themselves or someone else, or because they've been manipulated. People can do things that provoke others to criminal behavior. That doesn't make the behavior okay, but it makes the basis for it cognizable. People who don't do my job may think women and children don't lie about being sexually assaulted, for example. Guess what? They do, in ways that are provable. And before the brigade comes in, I'm a woman, for the record. Story 28. I cannot speak for other lawyers, but if I find myself wishing that, then that means it is time for me to file a motion to withdraw as counsel for the defendant. There are too many things that are a judgment call for the attorney. Should I object to that question? What should the tenor of my opening argument be? What order should I call my witnesses in? Who should I call as a witness? It is easy to say, well, whether I want him to be convicted or not is not going to affect my judgment and how I decide all of those issues. However, that would be my conscious mind saying that. I cannot say with my subconscious mind that my want for him to be convicted would not affect my position on things that are a judgment call, because I do not know if they would affect my judgment, and that is enough for me to want out of the representation. That being said, it would take a lot for me to want a client to be found guilty. I know the legal system we have is not perfect, but I believe it is the best way we have found to minimize both the number of innocent people being convicted and the number of guilty people walking free without consequence. That belief is what allows me to justify the morality of giving persons accused of committing the most heinous crimes the most robust defense I can, even if I know they actually committed those crimes. For me to want someone to actually be found guilty, my client would have to do something to personally and grievously offend me, which is a reason in and of itself to seek to withdraw. Story 29. Criminal defense lawyer here. If I'm ever in the situation of hoping for bad things for my client, I'm getting off the record and he can get a new lawyer. Doesn't happen often. Did happen once, with a person who had abused a child who wouldn't stop bragging about it. Realized I was beginning to genuinely want bad things to happen to him, so I told him it was time for him to get a new lawyer, which he did. Story 30. There are a lot of potential reasons. Lawyers refuse to take cases all the time. I probably refuse like 5 cases for every new one I take. In my area, there's just a lot more need for legal work than there are lawyers. Personal injury attorneys are known for taking a lot of cases, but it's not guaranteed. Try calling around to different personal injury attorneys. After like 3 or 4 have refused to take you, chances are it's because you don't have a good case. Rarely will attorneys tell you when you don't have a case. You have to come to that conclusion on your own after several attorneys have refused to take you. Story 31. I was, before I became an administrative law judge, a member of a federal district court's bar, admission to which required that I accept appointed cases. Because I was a civil lawyer whose office was in a different state, this was very burdensome on the one occasion I was appointed. Fortunately, there was a criminal defense attorney who called around whenever he saw an appointment order with an attorney whose name he didn't recognize and would ask to take the appointment from the inconvenienced attorney for a small fee plus assignment of the court's fees. In South Carolina, when I practiced there, every 403 qualified attorney had to accept appointed cases on either the civil or criminal list in the county in which he or she had an office. This led to the development of a system of secondary referrals, attorneys taking the appointed cases for a fee from the originally appointed attorney. Story 32. The public defender's office generally cannot choose what cases they get, yes. However, the offices can accommodate their lawyers. Because someone else in the office can handle the animal abuse cases, we're still good. I suppose our office could say, take these cases or you're fired. But we don't want my coworker to quit. There are also rules permitting a lawyer to withdraw from representing a person due to personal conflicts. Typically, I've only heard of this for cases where the client threatens or physically attacks the lawyer. However, I'm curious if that would apply to cases like this, where the lawyer has a personal ethical objection to handling the case. Story 33. So, story time. Had a client I thought for certain was obviously guilty. Accused of sexual assault by all of his many daughters. With very similar sorts of stories. He insisted that none of it ever happened, that it was a ploy by his ex-wife to mess him over. Seemed implausible, but the guy is entitled to a defense, so we're going to run it. One by one, daughters take the stand, and I have the unpleasant job of basically suggesting they're lying. One by one, they deny it. Until one of them doesn't. She tearfully admits that mom did tell her what to say, and that she misses her dad. And she's scared. So we bring the other daughters back in, tell them that the first one admitted it, and one by one they tearfully admit they're terrified and caught in a fight they don't understand. And so he's acquitted. The government enjoys tremendous resources to put people in jail, virtually unlimited funds, access to as many investigators as they want, scientific testing at a whim, all on the taxpayer dime. The accused, they get me. One guy, standing against all of that. Sometimes the accused are guilty, sometimes they're not. And I'm humble enough, barely, to admit that I don't always know which is which. So everyone gets the fullest defense I can give, because I want to know that anyone who goes to jail and has their life ruined had it coming. Can I choose my clients? Well, I can reject anyone who comes in the door for any reason that is not unethical. What's in it for me? Well, I get paid, but also the satisfaction of knowing that when the government comes for someone, there will be someone in the room to say prove it. Story 34. This is frequently the case in indigent defense. In general, we advise the client that the evidence against them is overwhelming, and if they are willing, try to work out the best plea possible. If the client wants to go to trial, they are entitled to do so, and we will do our level best to block the prosecution from proving their case. In many ways, the right to a jury trial is not only about ensuring the defendant's guilt, it's also about convincing a defendant that they are, in fact, guilty. They aren't always convinced, but I have certainly seen plenty of clients get a sort of aha moment after the evidence against them is presented by a prosecutor. Even assuming that they are guilty, it is my position that most sentences in the United States are wholly unproductive. Our jails do an absolutely terrible job of rehabilitating people. I don't consider retribution to be a particularly valid reason for punishing people. The deterrent effect of our current penal system is debatable, and arguably zero. It seems to me that we are throwing an awful lot of poor people in jail as an easy fix rather than trying to actually solve the problems that led to the crime in the first place. I have absolutely no qualms about securing a lower sentence or a dismissal for a client that I truly believe is guilty. I do not feel like there is any harm to society, and to the extent that there may be, I think that the harm is vastly outweighed by the negative consequences of our shoddy penal system. Story 35. Mitigation to avoid the worst possible outcome is part of any good defense strategy. So say I have a client who is guilty as sin, and upon first retaining me, he has absolutely no redeeming qualities to offer at a sentencing hearing. I advise my client to seek out rehabilitation and find some redeeming qualities to maybe mitigate the worst possible outcome on day one. This can make it easier for the prosecution to justify offering a reduced charge/more favorable plea, and it might also help get a more lenient sentence in a sentencing hearing. For a client with a driving while intoxicated charge, I would suggest Alcoholics Anonymous or a 12-step program. Wait, it's their third DWI? Then I'd advise they're going to pay to have an ignition interlock device installed in their car before anyone else tells them to. It's either that or an intensive 3-month inpatient substance abuse program, take your pick. If they were arrested with a large amount of a controlled substance, Narcotics Anonymous and substance abuse treatment, if a user, is for them. Not a user? Then all substance proceeds that haven't been seized under civil forfeiture are now a charitable donation to that substance abuse treatment facility. I still want them in NA so you can see how people are affected by the addictions you enable. For a client arrested for severely assaulting a homeless person, they're going to anger management classes, and then they're going to volunteer at the homeless shelter twice a week and asking for a letter confirming that they volunteered. If a client had harmed someone in cold blood and somehow they actually set a bail they could make, I'd advise that until the day of trial, their new home is the church monastery in this jurisdiction, and they're also enrolling and completing theological seminary courses. You can find God on the way, or not. It's the optics that is important. Obviously, doing those kind of things does not make a better outcome a sure thing, and it probably also depends on the jurisdiction. This video does not promote illegal activity. Stories are shared for commentary and education. If you feel unsafe with your thoughts, please seek professional help.